As mentioned before, the social construction of the genders does not present women as perpetrators of sexual offences. Sharma reports that the Indian government bowed to pressure from women activists and restored the legal definition of rape to an offence that could only be perpetrated against women. The opposition to making rape a gender-neutral crime raises the burdens encountered by female victims and exploitation by men. The burdens of female victims are associated with a societal expectation of virginity in women. The possibility of women coercing men into sex eliminates the burden of associating women's value with virginity. The prevalence of this possibility was highlighted in a survey completed by the Centre for Civil Society, in which 18% of adult Indian men reported being forced or coerced into sex. Besides, men also suffer the burdens of being labelled as gay, which is perceived as taboo in some society. The legal denial of women as perpetrators and men as victims of sexual crime in India is prevalent despite the 2007 statistics by the Indian government, which noted that 57.3% of victims of sexual abuse among children were boys. According to the Centre for Civil Society, Section 375 of the Indian Penal Code classifies rape as something only men do to women. The Protection of Children from Sexual Offences Act of 2012 protects children, but adult males are not recognized as victims and neither are women recognized as perpetrators. The Centre for Civil Society explains, and I quote, "In understanding what constitutes rape, international law has evolved from viewing it just as penile vaginal to penile orifice, and then to penetrative orifice, all within a non-consensual context. This explanation means that women forcing objects into other women's privates, such as female-on-female relationships, is not considered rape. Thus, failing to recognize women's ability to perpetrate rape implies that women are incapable of committing crimes of power." Eisenberg reports of efforts by women's groups to avoid the constitutional acknowledgement and conviction of female sex offenders based on the argument that it would scare women from charging men with rape in Israel. Notably, attorney Ruth Elder of the Noga Center of the Ono Academic College argued that the amendment would be used by men in defense accusations leveled by women. However, men still counter rape accusations on the grounds of falsification and obtained consent. Also, Stempel, Flores, and Meyer maintain that feminist organizations seek to sustain the perception of sexual assault as a patriarchal crime, which would be challenged by the focus on female perpetration. Eisenberg notes, and I quote, "According to the proposal, an amendment to the penal law, a woman who causes or makes it possible for a person to insert his, or her, bodily organ, or an object into her sexual organ, will be charged with rape, forbidden intercourse by consent, sodomy or sex offenses within the family, depending on the circumstances of the act." A successful amendment would not change the difficulty of providing evidence of a man being raped, increasing the risk of perjury lying to law enforcement. The amendment sought to amend the definition of rape, which stood at acts perpetrated against women. Attorney Eldar further argued, and I quote, "The law treats men and women as being equal when it is obvious that in these matters, the men are the stronger ones." This argument further promotes the perception and definition of rape as a patriarchal crime associated with the abuse of male privilege and power, as presented by various scholars, including Andrea Dworkin, Susan Bryson, Susan Brownmiller, Jean Hampton, and Kate Millett, who are documented by McKeever. The feminist presentation of rape as a product of patriarchy is also highlighted by Stempel and Meyer in highlighting the political unpalatability of violence perpetrated by women against men. The overwhelming focus on female sexual victimization ignores male victim, reinforces female vulnerability and presents women as always the disempowered victims. McKinnon argues that the United Nations General Assembly reinforced the discriminatory perception of rape in 1993, which termed sexual assault as a manifestation of unequal power and discrimination. Stempel, Flores, and Meyer argue that the feminist theory presents sexual victimization as an outcome of the social construction of male privilege and power that discriminates against women. The perception of rape as a patriarchal crime, which validates the need for the perpetrator to be male and the victim to be female, implies that all the crimes of the patriarchy only affect women and those that affect men should be ignored because of the radical feminist argument that men primarily created the patriarchy to benefit men at the expense of women. As mentioned in the social construction section, the male-on-female construct is the dominant perception through which sexual victimization is comprehended and discussed. The perception of women as harmless promotes the one-dimensional construction of women as incapable of having the negative traits possessed by empowered humans, eliminating the possibility of holding women accountable for their actions. According to Felder, the definition of rape in Article 345 of the Penal Code is the penetration of a female body without consent, thereby failing to acknowledge males as possible victims of sexual offenses. Attorney Vered Windman, who heads the legal team of the Israel National Council for the Child, notes, and I quote, "One mother had intercourse with 2 of her sons but was indicted for indecent acts, not rape." McKeever asserts that only men can commit rape under the current legislation in the UK, which reinforces the traditional stereotypes of women as being sexually passive. The legislations are founded on the assumptions that a woman cannot rape a man because of the underlying physical impossibility. Forceful penetration is more severe than non-consensual made to penetrate, and rape is not a gender-neutral crime due to the penis-centric perceptions of sex. The impossibility of a woman perpetrating rape is reinforced by the British government's White Paper Protecting the Public, preceding the Sexual Offences Act of 2003, due to the definition of rape as non-consensual penile penetration. The impossibility is based on the mechanics of sex, where the man has to be sexually aroused, evident through an erection. Physiological arousal signs do not evidence the willingness of sex. McKeever maintains that erection and ejaculation being confused as the willingness to have sex is similar to dismissing rape in a woman's case on the foundations of an orgasm or lubrication. McKeever also presents Susan Bryson's argument of rape being gender-motivated violence against women and Susan Brown Miller's assertion that rape is used as a tool of instilling fear in women. These presentations of rape argue against the gender neutrality of rape as diminishing women's experiences. However, men, especially male children, also experience rape. The difficulty of men reporting rape, in this case, is the perceived inability of a woman to rape a man. McKeever suggests that reforming rape law to make it gender-neutral undermines the problems presented by the general perception of sexual relations between men and women. The nature of the current law in the UK also implies that a woman cannot accuse another of rape in same-sex relationships. This phenomenon questions the validity of sex between lesbians, considering that a penis is not involved. Keith Burgess Jackson argues that the law reflects what people think and influences how people think. The criminalization of a husband raping their wife in the 1990s was perceived as the historical presentation of women as property and the lack of protection of their sexual integrity or autonomy. In the case of the current rape laws in the UK, men's sexual integrity and autonomy are not protected. This lack of protection remains, thereby failing to reflect sex equality goals and principles. All the assumptions listed above promote harmful stereotypes about male and female sexuality that are not essentially debunked as they are when discussing promiscuity. The stereotypes include: men always want sex, a woman's sexual purity is more valuable than a man's, and men, in the context of sex, are more active while women are passive. The thought of men always wanting sex results in women assuming it is okay to coerce men into sex and men assuming that they should go along with unwanted sex. These assumptions are worsened by the perception of the male species as sexually controlling, dominant, and potent. This thought of men always wanting sex is supported by Stempel and Meyer in their study that uncovered similar sexual victimization rates between men and women. The presentation of male victims of rape in media as a source of legitimate comedy is not similar to when roles are reversed. According to McKeever, these media presentations include Mark in The Peep Show, Jeremy Gray and Gloria Cleary in Wedding Crashers, and Matt Sullivan in 40 Days and 40 Nights. Such media presentations account for half the number of male victims reporting incidences of rape compared to their female counterparts, with the number being worse when the perpetrator is female, per the study completed by Vice. The idea of men having uncontrollable sex drives is used in validating the gendered definition of rape in the law. However, the idea is condemned in the belief that women should satisfy men that results in victim blaming. Men's uncontained sex drive is also associated with the lack of one in the context of women. Women's sexual purity is upheld across various traditions, including Hebrews and Muslims. Slut-shaming is mainly used by women to control their counterparts' sexuality by making them less desirable mates, as outlined by Armstrong. Harriet Barber maintains that perceiving rape as the worst thing that could happen to a woman reinforces the perception of women as sex objects whose sexual integrity surpasses everything else, including their intellect. The dominant role of men in the mechanics of intercourse fuels the stereotype of sex being something men do to women rather than something men do with women. This dominance presents consent as something men are given and women give. However, McKeever posits that equal sex is more collaborative and agreement-based than giving and taking consent. Weir supports McKeever's assertion through the argument that in England and Wales, only men are recognised as sex offenders, since rape victims are only those who are penetrated orally, anally, or vaginally by a penis. In other words, the forced to penetrate instances of rape are not accounted for in English law. The acts are convicted under the Sexual Offences Act of 2003 as sexual assault is coercion into sexual activity without consent. The Act, therefore, presents rape against male victims as less severe for actual criminalization. Weir explains that the need to classify forced penetration as rape is founded on the similarities between emotional and physical harms, underlying aggression, and circumstances concerning rape crimes against women. Mainly, aggression includes verbal pressure, intoxication, physical violence, and restraint. Intoxication and physical or mental disability invalidate the perception of men being physically more powerful than a woman. Gannon and Cortona explain that the shame and guilt of sexual victimization by a woman are worsened by the underlying social construction of the act being unusual. The resultant stigmatization, isolation, and alienation increase the risk of belief internalization from the perpetrator's standpoint. Focusing on aggressions to convict rape brings back old rape laws, where a woman needed to present physical signs of a struggle to show that sexual intercourse was non-consensual. Some American states, such as California, recognize sexual intercourse with an intoxicated individual beyond the ability to give consent as rape. Physical harms of the male victims include bruises, psychological and emotional harms such as fear, insomnia, tension, sexual disinterest, anger, trauma, fear boner, and inability to perform sexually. The perception that female offenders use less physical harm accounts for the minimization of sexual victimization against men. Definitions of rape in Washington in America and Victoria in Australia are gender-neutral by listing any form of non-consensual intercourse and recognizing compelled penetration as rape respectively. McKeever advocates for a more gender-neutral definition of rape in terms of forced intercourse, as in the case of Sweden. Taking rape as an instruction of power in heterosexual relationships is understandable, considering most people who report rape are women. The construction of rape is based on the historical definition, the historical prevalence of rape victims, and the illegality of buggery based on the Buggery Act overturned by the Sexual Offences Act of 1967. Vice states, and I quote, "Social ideals about gender may, especially contribute to non-recognition of men as victims. For instance, while social constructs of femininity, as physically weak and sexually vulnerable, fit overall perceptions of sexual victims, social expectations of what it is to be a man in our society, as strong, tough, self-sufficient, and impenetrable, counter images of victimization in general, and sexual victimizations in particular. With real men expected to avoid behaviors associated with femininity, men who are overpowered by others may be judged to have failed in their masculine duty, to stick up for themselves." Similar to the feminists in India and Israel, those in the UK also argue against reforming the law to identify women who perpetrate forceful penetration as rapists. According to Weir, the feminists argue that legally defining compelled penetration as rape will result in a gender-neutral approach to discussing and convicting rape, thereby obscuring rape as a female issue. However, identifying made-to-penetrate perpetrators as rapists will not affect how female rape victims are assisted in accessing justice. A point of concern or irony in Weir's paper is highlighting patriarchal culture which permits, and indeed encourages, men to control and subordinate women in an article that explores the discrimination of male victims of rape by diminishing the seriousness of the outcomes and the blameworthiness of the perpetrators, thereby presenting a female privilege and a male burden in the justice system through the violation of the parity principle. The term made to penetrate is still perceived to be awkward since the basic assumption is that a man with an erection wants sex. However, physiological symptoms linked to sexual arousal in women are not assumed to be actual indicators of arousal. The physiological misinterpretation is also the case for physical sexual signaling from women, which does not qualify as the willingness to participate in intercourse. McKinnon observes that the presentation of sexual assault as a gendered crime uncovers the failures in domestic law. Stempel and Meyer explain that rape often captures interventions, funding, and attention, while made to penetrate is often presented as secondary harm. The authors maintain that current FBI and CDC definitions still downplay the seriousness of sexual violence perpetrated by women. Shields and Cochran explain that the disparities in gender sentencing are adverse outcomes of strategies by get tough punishment movements that advocate for more use of prisons and sentencing times. Qualitative research is fundamental in highlighting contextual factors that inform gendered sentencing for sex offenders. Overall, the unfairness in the justice system evidences policy failures. Sex offense-related policies should promote sentencing equality irrespective of gender. The impact of policies should be examined along the lines of reducing reoffending rates and punishing offenders. Policies should not be more punitive to any gender but should seek to promote equality in instances where crimes are similar. The impacts of over-reliance on incarceration, such as reverse outcomes, should be examined for improved efficacy and implementation. There is limited research on the emergence of gendered perceptions about sex offenders, or how female offenders are a lesser threat to the community. The media has played a significant role in shaping individuals' views of sex offenders, especially male perpetrators. Additional talking points on the sex offender sentencing include the relationship between the victim and the offender, and the victim's age and gender. Mainly, victim characteristics present gender dynamics similar to offender attributes, which contributes to disparities. Shields and Cochran suggest that court decisions should be based on available evidence instead of stereotypes and irrelevant individual attributes associated with information shortage. For instance, heavier prison sentences for male offenders should be based on the risk of reoffending, and rehabilitation sentences should be guided by the nature of the crime and the history of criminal involvement. Determination of dangerousness should not rely solely on gender, but on additional factors including mental health problems. Directions for effective future research are also fundamental in obtaining a clearer picture of gendered differences in sentencing. First, closely tying case-based and statistical methodologies should be used in comparing and presenting cases. This phenomenon enables the comprehension of difficulties presented by quantifying harm, especially in determining the causes of disparities. Second, comprehending the impact of gender determination in decision-making should be documented. For instance, minimal differentiation between criminalization and victimization in women's profiles contributes to disparities in the perceived blameworthiness of female offenders. Third, MacLeod suggests that focusing on women without necessarily involving comparisons with men could present a more detailed description of offenders. The offense context, causes, seriousness, and underlying negotiations are notable attributes that could describe gendered sentencing. Fourth, moving research away from equal treatment models eliminates the regard for harsh treatment in some instances. The models were used in examining race-based sentencing, but modern scholars utilize context-dependent methodologies that analyze the underlying disparities. Stempel, Flores, and Meyer suggest that policy and public health responses should embrace gender inclusivity in dealing with sexual victimization. This inclusion should encompass increased professional attention from criminal justice and healthcare providers, inmate consideration in sexual victimization discussions, and comprehensive sexual victimization research. The authors also observe, and I quote, "Unless we uproot the simplistic stereotypes that limit understandings about sexual victimization, we will not address it accurately, nor will we respond to victims empathically. Those victimized by women are doubly harmed when we fail to treat their abusers worthy of concern."